not on camera. I don't know if you want to be or not, but just to let you know, you are not yet visible to us. And you're on mute. Before we begin, everybody, I just want to make sure Mr. Winter can hear us and that he can be heard and that he can be seen if he'd like to be seen.
Yeah, just give me a minute, judges. I apologize.
We can see you and hear you now.
There we go.
All right, great, thank you. Welcome everybody to the First District Court of Appeals. We have 3 cases set for oral argument this morning. The first is Setters versus Durrani. Mr. Winter is here on behalf of appellant. Mr. Herzig is here on behalf of appellee. Mr. Winter, you will have 15 minutes to argue this morning. Would you like to reserve any time for rebuttal?
Let's try 5 minutes, Judge.
All right, and I will keep your time whenever you're ready.
Okay, thank you. Good morning, judges. Mr. Herzig, Bob, we're on behalf of Dana and Craig Setters. The double line position of the Setters is that the case below, with regard to the trial court's addressing of the third assignment of error, ended on approximately April 6, 2021, and consequently the third any review of the third assignment of error from the first appeal is over. Here's why. The facts are that Dr. Durrani and Cast appealed. Judge Krause wrote an opinion that addressed the 4 assignments of error. 3 of them were reversed. 1 of them we conceded that a set off with regard to a settlement with Westchester Hospital and UC Health was appropriate. Excuse me. Did I lose you?
No, and this would also be a good time for me to just interject for a moment. I neglected to say before you started, Mr. Winter and Mr. Herzig, that this is a cross appeal. So each of you will have an opportunity to reserve time to address your own reply and your response to the other side. So I apologize, I didn't say that at the beginning. Mr. Winter, I'm going to add a minute back to your time since I took a little bit of it.
Judges, can you see and hear me?
Yes.
Okay. I can't see you, but I'll fool with that later. Anyway, the case came back. The case was remanded by this court based on its limited remand jurisdiction to the trial court to decide my client's actual damages considering the set off. And it did so. And on March 4th of 2021, it entered a judgment entry on remand. It's document 333, and the judge indicated it was a final appealable order. There was no appeal back to this court in any way, shape, or form. There was, however, a Rule 60 motion, and we've indicated that the court that does not grant any court jurisdiction. I wanted to point out as a matter of fact, that Judge Brogan had indicated that the plaintiffs had agreed that the court, excuse me, the plaintiffs had agreed that he lacked jurisdiction in March of 2021 to enter the entry or on judgment remand. I would like to just call your attention to the specific statement by plaintiff's counsel that we never stated that the court lacked jurisdiction. If you look at document number 335, page 2, we did state that an appeal on the three matters that Durrani and Cast appealed to the Supreme Court, did not permit Civil Rule 60B motions for relief from the judgment. While the court certainly possessed jurisdiction to enter the judgment entry upon remand in March, there was no jurisdiction to consider a Rule 60B motion. And that authority can be found in the Howard versus Catholic Services case at page 147. So again, getting back to where we were at, there was no appeal taken from the entry of judgment entry upon remand. It was obligated under the scope and the law of this court's limited remand jurisdiction to come back to this court if it didn't like what was done at the trial court. That was never done. And so 30 days after the entry of the March order, that aspect of this case became final. The court had jurisdiction to consider the entry upon remand because under the Howard versus Catholic Services case, the trial court possessed limited remand jurisdiction over the issue of Westchester UC Health set off because it didn't impair or impact in any way the Supreme Court's ability to alter, amend, or vacate the three issues that were before it.
But if the Supreme Court would have taken the case and reversed us, then the defendants either would have gotten a new trial or damages would have been reduced. So how is that not inconsistent with what the trial, I mean, the whole case, the whole posture of the case would have changed. I mean, the set off is simply reducing the damages as they were affirmed by this court.
Yes.
But the issue on appeal that they were trying to get up in the Supreme Court, one of them was a new trial completely, and one of them was, I believe, on damages issues. So I don't understand how the lower court had jurisdiction at that stage.
And I mean, the damages issue was dealt in the third assignment of error.
So you're saying they part of their appeal, and I'm sure they'll tell us, wasn't part of a damages issue?
That's my understanding, Your Honor.
So what is your understanding of what they were appealing?
Judge, there were three issues. The first, they admitted they didn't like the admission of Dr. Durrani's license revocation and prior lawsuits and excluding similar evidence about our expert orthopedic surgeon, Keith Wilkie.
And that would have, and if they won on that, that would have resulted in a new trial, correct?
Yes.
Okay.
Yes. And then the trial court denied their motion JOV or new trial on the specific items. And the third was that erred in not remitting amounts spilled over the amounts paid as past medical expenses. Those did not deal with the amount of set off received by the setters from UC Health and Westchester Hospital.
But it dealt with damages in general and the reduction in damages, right?
What was there was the reduction in whatever damages would ultimately come from a new trial. Those items were fixed. There was nothing more to decide. If there was a new trial, then damages would be affixed, if any, and then they would be reduced by what the trial court had done in its March 2021 order. Those were
The trial
fixed.
court the trial court would have to redo the whole set off thing if there was a different damage result, right?
No, it's done and over with. The damages that the setters would incur, if any, would be tried. But let's just say there's a higher number or a lower number. Whatever that number came in, they would be reduced appropriately by what was entered in March of 2021. And so that wouldn't affect what the Supreme Court was doing or would have done esoterically had Dr. Durrani and Cass prevailed.
And you have one more minute, Mr. Winter, if you want to reserve 5.
Okay, I'm going to just continue to reserve everything after April of 2021 on the third assignment of error. The trial court didn't have subject matter jurisdiction, including all the orders entered in July of 2021. So consequently, we would ask that the trial court orders of those of July 2021 be rendered null and void without subject matter jurisdiction, and that this court would enforce the March of 2021 judgment entry upon remand consistent with the court's limited remand jurisdiction. Thank you.
Thank you, Mr. Winter, and you are at your time. Mr. Herzig, you will have 15 minutes total. Would you like to reserve any of your time for rebuttal?
I would, Your Honor. I don't expect to use the whole amount, but I'll reserve 5 just in case.
All right, and whenever you're ready, I'll keep your time.
Thank you. Good morning, Your Honors. Aaron Herzig on behalf of Appellees Cross Appellants Durrani and Cass. May it please the court. I think Judge Krause asked the right questions on the jurisdictional issue on the appeal. The questions were exactly right. The fact is that the issues we sought jurisdiction over would have resulted in a new trial, potentially other parties being added to the case. We had raised the real party and interest issue that comes up in these cases, and we had addressed whether the damages were in fact catastrophic under Ohio law. So had the Supreme Court taken our appeal and reversed or modified the case in any way, there would have been different questions to ask. Set-off might not have been an issue at all if, for example, Dr. Durrani and Cass were found not liable after a new trial. So we think the case law is very clear in our favor that lower courts do not have jurisdiction when it would affect the decisions that are being made in the courts more superior to them. That's exactly what was happening here. We think it's a pretty clear case. Unless you have particular questions on that, I'll move to our cross appeal, which is the substantive issue. And frankly, one we also think is very clear. What happened in this case is that the trial court decided the amount of set-off for other settlements from other co-defendants without ever giving Dr. Durrani and Cass the ability to review or challenge the evidence, cross-examine witnesses. In fact, it's probably not even competent evidence that the judge looked at. What the judge requested and received from plaintiffs was by email, by the way, not by a docket entry, despite our objection, was a summary, allegedly, of a settlement between the plaintiff and Westchester and UC Health. We were not provided with the settlement to be able to verify it. It's not even in an affidavit or other sworn testimony. It's arguably not competent evidence at all for the court to look at. In fact,
did the court request or review in camera the actual underlying settlement documents?
We don't think so, Your Honor. Unfortunately, we don't actually know what the court used, but according to my colleague's brief, he points out that the court didn't look at the entire settlement agreement. He only looked at the summary, and that's particularly problematic. So, but again, it's documents that we have not even seen. To us, this is a fundamental.
Can I ask you though, why would the defense need to see the settlement agreement? I mean, if, as you say, the record's not clear if the court actually did an in-camera review, but we're looking at the number, right? That's all you need is the final settlement number. Why would the defense need to see the whole agreement?
It's possible, Your Honor, that we wouldn't. And we understand that there are confidentiality concerns from our settling co-defendants, and we're not trying to invade that, although there'd be plenty of ways for us to avoid making anything public through in-camera review or attorneys only review, all of which we had suggested. But the problem here is we don't even know if the number is accurate. They could have said they could have all agreed, yeah, it's $10,000, when in fact it's $1 million.
Would you have been satisfied if the judge said to you on the record, I requested a copy of the settlement agreements, I reviewed it in chambers, here's the number that I'm going to reduce it by based on the settlement agreement? Would that be good enough?
I don't think it would, Your Honor. That's not evidence. That's not an opportunity for us to challenge the information. I think if we're looking for the very minimum, if we're looking for a procedure, because this does affect a lot of other cases that are coming your way, Your Honors, one potential solution could be affidavits actually swearing, having the plaintiffs actually swear and the co-defendants actually swear to the veracity of the information. Let us see that. We may not have grounds to challenge that if we get to that stage, and then we wouldn't have an issue. I'm not saying I'm not.
You're basically arguing, it sounds like, that the plaintiffs have some issues with veracity, and you don't trust what they're representing to the court as basically officers of the court.
No, Your Honor. I'm not suggesting that at all. I'm suggesting that our adversarial system requires that we trust but verify is really what we look at. I, of course, trust other officers of the court, but I am also entitled to verify the accuracy of it. And as we all know, there are times when one person's view of evidence is different than another's. We don't know all the mechanisms of the settlement. Our understanding is that they were global settlements across many hundreds of plaintiffs.
How would you verify the accuracy of an affidavit by plaintiff's counsel?
Well, again, I was proposing one hypothetical, and we're not consenting to any particular process here today, but that was one hypothetical. And as I said at the end of what I was saying, we might not, if we had sworn statements from the plaintiffs and from the settling co-defendants, there might not be much need for us to have questions about that. That could be a solution. But a basic tenet of our process is that, of course, we get to challenge even truthful witnesses and make sure that we understand their testimony, the basis of their testimony, and then a judge gets to decide, because a judge still has a standard he has to use. He still has to find by a preponderance of the evidence that what he has decided is accurate in a situation like this. We'd have an opportunity to test that.
What would you really be doing? So you get a copy of the settlement agreement and it has a number in it, and that's the number that the damages have to be reduced by, correct?
Yes, it could be.
What else are you going to do as far as testing that?
We might not need anything else, Your Honor, but right now we're being asked to simply presume that everyone else everyone else who has the evidence gets to say what it is, and we, as the parties who ultimately have to pay the damages, don't have an opportunity to challenge that. I mean, I think that's really problematic. In a DUI, if the government says I blew over the limit, and the judge looks at the evidence and says, "Yep, that was over the limit," the defendant still has the opportunity to challenge the veracity of the machine and the people testing it. While we're not in the criminal context, the adversarial process and due process under the Ohio and federal constitutions work the same way.
Mr. Herzig, if this was a global settlement, and I don't know whether it was or wasn't, and the settlement agreement really was a global number, then there would have to be some allocation among the different clients of Mr. Winter's office, presumably either done by their office or a special master of some kind. Would you be satisfied if there was an independent, I'm just calling it a special master, who took that global settlement and calculated it to the plaintiffs? Would that be satisfactory?
Your Honor, I think potentially, but ultimately, and again, our interest is not in just seeing a settlement agreement for the sake of seeing it. And if there are confidentiality concerns, we have told all the parties involved that we would be willing to work with them to figure that out. But I think at minimum, for it to be actual evidence that a court can consider, it's got to be sworn. And we've got to have a chance to see what it is. This summary that the court allegedly based its decision on, that might be enough. If we have the other underpinnings of actual testimony, there might not be a challenge here. But we are completely in the dark right now. We don't know. We don't know what the evidence was to calculate the set off. It would be useful for us to be able to test the accuracy of that. In fact, we think it's required by due process. And so that's what we're looking for. And I will say, Your Honors, this is the first of, as I mentioned, several cases that will deal with this. This one only has a couple of settling co-defendants. In other decisions that are coming your way, the court has to figure out if there are even more settling co-defendants. There are, in some of these cases, other settling co-defendants. And the judge is deciding on his own, whether the right co-defendants are in the case. That's not before you today, but just so you understand the implications of what this case may mean.
And just trying to understand, I know that your brief or your argument in your brief is stating that you all should be able to review the settlement agreement. But some of the things that you're saying today there are ways around that are short of the defendants the settlement agreement being provided to the defendants. You talk about affidavits. I raised the issue of an in-camera review by the judge, and you said not good enough. So what about a combination of an in-camera review by the judge and then affidavits by the parties? Would that be enough? Or is the only solution that the defendants get to look at the settlement agreement?
No, Your Honor, what I think my view is the right answer coming out of this court is a remand for a process that is consistent with due process. We attempted to talk to all the parties involved, including the settling parties and the court, about what might work to satisfy us. We're open to things like what you just discussed. I'm not sure, though, that I can give the court today a solution that say my client would consent to. But I do think at minimum, you need sworn statements from the people making the statements and our ability to see those statements. I think we probably have the right. In fact, I'm fairly certain we have the right to cross-examine people who have made sworn statements, just like you do. Someone submits an affidavit that we don't have to accept it. We are allowed to cross-examine them. Now, I think to your point, Judge, we do get to the point where maybe there's not much for us to challenge, and that's fine. We would like to be in a position to know an answer that we can rely on, that is competent evidence that satisfies due process. And yes, then there might not be a debate. But
Mr.
right
Herzig,
now, we're not even close to that.
You are at your time, Mr. Herzig, unless there are other questions from the panel at this point. Mr. Winter, you have 5 minutes remaining.
Thank you, Judge. If I can just make sure I've affirmatively answered Judge Krause's question. The set-off that was determined under the limited remand jurisdiction from this court would be the same, regardless of whether the Supreme Court would have reversed any of the three matters. damages would be recalculated at new trial and a set-off imposed or applied against those new numbers. Nothing, they would be the same. Of course, we don't get to that point because the Supreme Court never got to that point.
Mr. Winter,
Yes,
what evidence, what in the record is before us that would allow us to determine how the judge determined the set-off amount?
it would be at document 339, which is his decision of July 26, 2021, at pages 5 through 7-ish, may go on.
But is there anything in front of us? For example, we don't have the settlement agreement itself if it was reviewed in camera. We don't have any emails that were sent. What is in the record that we can satisfy ourselves that it was properly done?
It would be the appendix. Golly, judges. It would be the appendix to that decision, indicated where the judge himself reviewed the emails and summarized.
But it was basically emails, right?
That's
what the judge reported, that he got an email from the plaintiffs and an email from the settling parties.
And he also received what I think is very important was counsel for UC Health, Melissa Korfhag, and the judge discusses that at page 5 of document 339. But
that was an email from her?
No, it was his quote of what she said. I mean, it wasn't the actual email, judges. It was a quote. But
an unsworn statement, though.
I've no indication that it was sworn. That's true. You know, it was just representations by my plaintiff's counsel and Ms. Korfhag. Yes, ma'am.
Did you offer the settlement agreement in camera for the court's review?
It would have been offered. It was never asked for by the judge. I have no indication that it was tendered to him for review. Had he asked, we'd have provided it.
So how does this comport with due process when, well, first, you know, they all they have is some email or communications between plaintiff's counsel and the settling parties with the judge,
and from UC counsel for UC Health, Westchester Hospital. The judge found those satisfactory. But first, let me, before we're getting a little ahead of ourselves, we never get to this point that Mr. Herzig raises, because the case ended on the third assignment of error in April of 2021. All these matters were brought up later, as I understand it. And the judge thought it was sufficient, that the quantum of evidence that he received from plaintiff's counsel is confirmed by UC Health Westchester Hospital's counsel, and as he's articulated in document number 339. And I just want to point out, if I may, that by the way, his summary is at pages 9 through 11 of document number 335 of 335. Yes.
And Mr. Winter, you may finish this thought, but you are at your time.
I just wanted to say that the defendants got a fair shake. That my predecessor attempted to reduce the set off from 160-ish to 130-ish K, and Judge Brogan rejected it. And I request that, as stated in opening, that the March 2021 order be deemed the final order. Everything beyond April of 2021 is null and void. Thank you.
Thank you, Mr. Winter. Mr. Herzig, you have 5 minutes remaining.
Thank you, Your Honors. I would simply, I don't think I have anything particularly new to say other than our motion was a Rule 59 and a Rule 60. So there would still be appellate jurisdiction even over the Rule 60 denial that the court made. It raised the issue here of due process, which is properly under Rule 60B if necessary. We don't think we get there. We think the court plainly lacked jurisdiction because, again, the action of the trial court might have been null and void if the Supreme Court had taken the case and then reversed for a new trial for different damages to add additional parties and the like. So we think jurisdiction clearly was lacking here. And then we think due process also was lacking. We request that this court remand the case for the trial court to properly proceed to figure out the set-off amount in this case.
Thank you. Thank you both for your arguments this morning. We will take the case under submission and we will give you a timely written opinion. And Ms. Hayden, if you will bring the next parties into the courtroom.
Thank you, Your Honors.
Judges. Thank you.
Good morning, counsel. The next case on our docket this morning is Helton versus Fifth Third. Mr. Schlichter is here on behalf of appellant. Mr. Walton is here on behalf of athlete. Mr. Schlichter, you will have 15 minutes this morning. Would you like to reserve any time in rebuttal?
Good morning, Your Honor. I'd like to reserve 3 minutes.
All right, and I will keep your time whenever you're ready.
Thank you, Your Honor. Good morning, Your Honors, and may it please the court. Andrew Schlichter on behalf of the Clark siblings. The trial court erred in re-entering summary judgment on the excessive fee claim following this court's finding that summary judgment on that claim was improper for a multitude of reasons. I'd like to focus on at least 2 of them this morning. First, the trial court's re-entry of summary judgment inescapably conflicts with this court's 2019 opinion in Helton, which found summary judgment on the excessive fee claim improper.
May I interrupt you? Wasn't that on the basis that it wasn't barred by the statute of limitations because it wasn't a claim as the other claims were? And that's the only issue that was presented to us at that time, wasn't it?
That's correct, Judge Myers. That was the only issue that at that time Fifth Third raised. However, the issue that the court decided was whether any genuine issue of fact precluded summary judgment. And if you look to the Hood case that we cited in our papers, you'll see that that issue is the same here as it was there. The court's review was de novo and considered all of the evidence in the record.
Well, but I'm going to push back a little bit on that. Nobody raised the issue that you're raising now, did they, at that time? In other words, the court never had before it and never decided the merits of an unjust enrichment claim.
We would submit, Judge Myers, that the court did so by ruling that summary judgment was improper. And what I would just note, Your Honor, is that if you look at the Bergkamp case, which is a case that Fifth Third repeatedly relies on, that case makes clear that where a party has available to it an argument and evidence, but fails to raise it on a closed evidentiary record, then the party is precluded from raising it on a subsequent motion for summary judgment following an appellate court's reversal of summary judgment. And in fact, there is no case that Fifth Third has cited that holds to the contrary. That is, that a party may file serial summary judgment motions based on evidence that was in a closed evidentiary record, but it simply didn't decide to bring to the table, or arguments that were available that it simply didn't raise.
So your position is that if someone brought a motion for summary judgment on statute of limitation grounds only, and that was subsequently reversed, that they would be precluded from addressing the claims on the merit in a subsequent summary judgment motion?
That is our position, Your Honor, where the evidentiary record is closed and that argument was fully available to be pursued. And that is the holding of the Hubbard case. It's also the holding of the Bergkamp case in which Fifth Third repeatedly relies. And that Bergkamp case says, I'll just read the relevant language. If in subsequent proceedings on remand from a reviewing court, the moving party founds his or her summary judgment motion on an issue which is based upon the same record and could have been presented in the first appeal, he or she is precluded from pursuing that motion by the doctrine of law of the case. We would submit, Your Honor, that the Bergkamp case, Berlekamp case, is on all fours here, and the same result as in that case should be found in this case. The second issue that I'd like to address this morning, setting aside this court's prior ruling on law of the case, the trial court's finding that the Clark siblings cannot bring their excessive fee claim on behalf of the trusts is directly contrary to both the Ohio Trust Code and the common law of trusts and is incorrect as a matter of law. But before I address these points in any further detail, I want to be absolutely clear regarding the central premise of Fifth Third's argument. We are in complete lockstep with Fifth Third regarding the fact that because the Clark siblings were remainder beneficiaries throughout the relevant period in which Fifth Third was removing its grossly excessive trustee fees, they could not personally have conferred any benefit on Fifth Third. That was true in 2015, nearly 7 years ago when this case was filed. It was true in 2019 when this court found summary judgment improper on the excessive fee claim, and it is true today.
Well, then let me ask you this, Mr. Schlichter, and kind of cut to it. I reviewed and re-reviewed the complaint, and I don't see anywhere in the complaint where your clients purport to be bringing this action in any capacity other than their individual capacities as beneficiaries of the trust. And I think there would be different arguments if they were bringing the action to recover funds to be deposited back into the trust. But help me with the complaint and point me to something that would support your argument that they're not bringing this claim individually as income beneficiaries.
Sure. So first of all, Your Honor, to be clear, we believe that explicitly in the complaint, and there are various mentions of it, but, and by the way, the complete complaint is incorporated by reference into the unjust enrichment claim in paragraph 58. But we believe that the complaint does allege a claim on behalf of the trusts.
Show me where, any paragraph, because I know that's your argument, and you asked for disgorgement and that the disgorgement be to the plaintiff beneficiaries, not to the trust. You asked that there be an equitable trust put on and that Fifth Third be ordered to disgorge it. The reason I'm asking this, I do think there's a difference, perhaps, between recovering individually and recovering on behalf of the trust, and I'm just not convinced you've alleged anything on behalf of the trust.
Your Honor, we would argue that it does, and regardless, though, it's a distinction without a difference ultimately, because if it's not explicit in these few paragraphs that are paragraphs 58 through 63 in the unjust 64 in the unjust enrichment claim, is set forth throughout the complaint. At the very least, it's implicit because the Clark siblings were not able to recover as remainder beneficiaries. They could not recover based on Fifth Third's wrongdoing because they were remainder beneficiaries throughout that entire period. So
they didn't have a claim at that point.
I'm sorry, Judge Cross?
They didn't have a claim at that point, though. They could have only brought claims on behalf of the trust. Is that what you're arguing?
Exactly, Judge Cross. There would have been no claim for them to bring. And I'd point out in our 2017 expert reports, 5 years ago, we specifically sought damages only on behalf of the trusts. We have repeatedly disclaimed seeking any damages individually. The paragraph 59 references a constructive trust. These damages wouldn't go to the Clark siblings individually. And I think, Your Honor, Judge Myers, the language that you mentioned with respect to disgorgement, implicit in that, just like implicit in the fact that the Clark siblings are bringing this action as plaintiffs, is that they are seeking that those funds on behalf of the trust. That is what we have said throughout this litigation. And of course, Rule 15, Civil Rule 15B specifically says that where there is no objection to the way in which a party pursues litigation, then the issue is tried by consent. And if you look at the Andrew case that we've cited, for example, I think it's clear that where the defendant did not object in that case to a lack of specificity in the complaint in earlier stages of the proceedings, the issue was tried by implied consent. Here we have 7 years of litigation, hard fought fact and expert discovery. Fifth Third did not raise that argument in its 2015 motion to dismiss. It did not raise that argument based on the complaint in its motion for summary judgment, which was the basis for this court's ruling in 2019. And it did not raise that argument at any point throughout discovery, despite all the expert reports and our express statements that we are only pursuing this action on behalf of the trust.
This might be a little off point, but who is the current trustee of the trust?
Fifth Third.
And they've been the trustee the entire time. Wouldn't, in order to bring a claim on behalf of the trust, wouldn't the beneficiaries have to make a demand on the trust to bring the claim, and then only if they fail to do so?
No, Judge Myers, they don't. That's not the law. And if you look at the Ohio Trust Code, any beneficiary is able to bring a claim on behalf of the trust. That's in the restatement, that's in the law. And I direct your attention to the Woltering case, which I believe you may have been involved with back in 1999, in which remainder beneficiaries, just like the
You
Clark,
really tested my memory in 1999.
the Clark, remainder beneficiaries in that case brought a breach of trust action against a trustee, and the proceeds went into the trust. That's exactly what we seek to have happen here. This is really not a new fact pattern. This happens all the time. And the idea that remainder beneficiaries lack standing to bring lawsuits against a trustee really would represent a significant weakening of the Ohio Trust Code if that can't happen, which would obviously impact folks who have their assets managed by fiduciaries and trustees, specifically the elderly, retirees, and the infirm.
And I guess I guess what I'm still struggling with is whether you've properly brought that claim on behalf of the trust. And I think I've probably asked you all the questions I have, but I think I'm not disagreeing that you can bring an action on behalf of the trust, just whether in this case your clients properly have.
There has been, Judge Myers, in the 2015 motion to dismiss, in the motion for summary judgment, the first motion for summary judgment filed by Fifth Third that was appealed to this court, in its second motion for summary judgment that was denied by the trial court, in its third motion for summary judgment, which was ultimately granted, Fifth Third has never raised that argument. So if that argument was available, was an argument that could have been pursued, presumably Fifth Third would have raised it in one of its four motions for dispositive relief in this claim. And we would rest on our papers with respect to the provisions of the Ohio Trust Code that allow remainder beneficiaries to bring actions on behalf of trusts.
So this case has been litigated under the assumption that these claims were brought on behalf of the trust.
Judge Krause, that's specifically what our expert Matt Gutzweiler said in 2017 in his expert report. He sought he indicated that we were seeking damages only on behalf of the trusts. That is what that expert report says. That is what his second expert report in 2017 says. Our other expert, Ed Higgins, one of our two other experts, cited all the provisions of the Ohio Trust Code, explaining in a very detailed 50+ page report how the trustees can recover on behalf of trusts and can recover for this type of unreasonable removal of trustee fees. So yes, that issue has not only been litigated, it has been extensively made clear. And Additionally, Your Honor, the Clark siblings have stated repeatedly that they bring this action on behalf of the trust have disclaimed any notion that they're not doing so. They would be judicially stopped from taking any other position in this litigation. So there's no dispute, no doubt that this is only on behalf of the trust. Again, we don't disagree with Fifth Third that if it weren't on behalf of the trust, there would be no claim to pursue.
Mr. Schlichter, you are at your time. You will have 3 minutes left in rebuttal. Mr. Walton, you have 15 minutes.
Good morning, Your Honor. May it please the court. My name is...
May I have you jump right in where Mr. Schlichter left off, and I'll do that by asking you a question if you don't mind.
Yeah, Your Honor, I was going to address your questions immediately.
If this court would determine that his clients are bringing this on behalf of the trust, would you agree then that your argument with respect to conferring a benefit goes away?
No, Your Honor, absolutely not. First of all, and I believe Judge Krause asked this question as well, there is no such claim under Ohio law, common law, or the trust code as bringing something on behalf of a trust. But even as I'll indicate, even if they could, it doesn't matter. There is no such thing under Ohio law as a derivative claim for bringing something under Ohio law. And their status as a beneficiary does not matter because as individuals, which you correctly noted, they're bringing this claim for unjust enrichment as an individual, they did not confer a benefit. And Mr. Schlichter's admission that they haven't conferred a benefit ends this case. In addition, the trust never conferred a benefit upon Fifth Third, and that is undisputed. The income was never taken from the corpus of the trust. So even if they could bring a claim on behalf of a trust, and you can't, you're in a trust case, as the court knows, you're either a grantor, a beneficiary, or a trustee. There is no trust case. Even if they could, there was no income removed from the corpus of the trust, and therefore, as this court said in Defrin, the first element of cannot be met. The trust did not confer a benefit on Fifth Third. The fees were paid at that time, and it is undisputed, by the then income beneficiary, their mother, prior to May 1st, 2015. And
so
again,
it's your position that the only person who could bring a claim for excessive fees would have been the mother as the income beneficiary?
Prior to May 1st, 2015, it was the then income beneficiary because she received the benefit. She received the fees at the time, Your Honor. And in this case, going to exactly what you said, all they have in this claim is a common law unjust enrichment claim. That's all that exists. And when this came down, originally, we litigated the issue of the duty to diversify as a basis of unjust enrichment. When we went back down before Judge Winkler, it was the plaintiff's inability to meet the elements of unjust enrichment. And this court's holding in Bondahar is dispositive. When you have different...
That case didn't change the law in any way, did it? It just, I mean, that's always been an element of unjust enrichment.
I think as Judge, well, first of all, Your Honor, I think as Judge Winkler noted in his opinion, I think it's on paragraph 4 or 5, it clarified the law of unjust enrichment. And what it said is, it was the quote, first element is that the plaintiffs themselves must confer a benefit. And Judge Winkler, I would note, always has at his discretion, as does any trial judge, to reconsider his decisions. And Your Honor, I think this is not unlike, for example, in 1928, the Paulsgraf v. Erie, our Long Island Railroad case was decided. We are still getting decisions today that refine and discuss the elements of negligence. What the Defrin case did is it made it clear a court or a litigant has to look at the first element, and it's whether a benefit was conferred. And as Mr. Schlichter said, and Judge Winkler found the undisputed evidence is, these individual plaintiffs did not confer a benefit upon Fifth Third. In addition, the trust did not confer a benefit. The only benefit that was conferred was done by their mother, who was the then income beneficiary at the time.
Why wasn't this never raised previously?
I'm sorry, Your Honor.
Why wasn't this issue raised? Why wasn't it raised previously? I mean, this would be another ground, right, for summary judgment.
Your Honor, because at that time, and I think as the court noted, this case has been litigated for 7 years. Over that time, the entire issue that was being litigated was the failure of the duty to diversify. And so the parties were not focused on fees as a basis of unjust enrichment. They say, and I want to also note, one of the things the case law says is the law of the case doctrine is a rule of practice. And the Supreme Court has said that it should not be applied to create an unjust result. And in these circumstances, what could be more unjust than having Fifth Third go back before Judge Winkler on the issue of unjust enrichment on the same factual record, which shows that no benefit was conferred, as Mr. Schlichter has indicated, and then again, to come to this court on an appeal. That issue was not. And the other thing I would suggest, Your Honor, is it is impossible, as this court is aware, to raise every single issue that could conceivably come up on a summary judgment briefing. In that case, no one would ever have summary judgment because there would always be some argument. We moved at the time, and it's when this court on remand said it could conceivably be something other than the duty of diversify. We went back, and I would note at that time we had different facts and different legal issues. The parties submitted both plaintiffs and Fifth Third submitted 4 affidavits, 75 exhibits, I think over 12 depositions. It was different issues and different legal issues and different facts when Judge Winkler ruled. I do want to note, Your Honor, something I think that's important. They attempt to distinguish Deferent, but none of those distinctions matter. They suggest that summary judgment was improper because Deferent did not overrule or reverse this court's decision in Helton. But I think that argument is nonsensical. Helton did not discuss, let alone elaborate on the elements of unjust enrichment. In addition, Deferent did clarify the element of unjust enrichment, which is the sole remaining claim in this case. And Deferent was decided after Helton won. In light of those circumstances, the trial court correctly applied the holding in Deferent to the plaintiff's remaining claim for unjust enrichment, and in fact, rightly reconsidered its first ruling on remand in light of the intervening nature of Deferent. And again,
are you suggesting that prior to Deferent, there was a question about who had to confer the benefit on the alleged unjust enrichee?
No, Your Honor, I don't think it was. I don't think that's true. But I think what the holding that stands out in the Deferent opinion from the First District is the statement, it is the first element. I think in the past, quite frankly, people would look at who received, what was the benefit received? What did the defendant get? What was the enrichment? And here, the First District has laid it out clearly that the plaintiff themselves must confer that benefit. And we don't know from Judge Winkler's opinion. He said that in his opinion, and also in ours, the First District clarified the elements of Deferent, or clarified the elements of unjust enrichment. And based on that, he reconsidered his opinion, as is his right, and applied the facts to the law and determined that summary judgment was warranted from Fifth Third because they had not conferred a benefit. The other issue I'll mention is they indicate that Deferent is somehow inapplicable because it is not a trust case. And I would submit that this is a red herring. The plaintiffs have a single remaining claim, and that's a common law claim for unjust enrichment, as their complaint makes clear. There is nothing under Ohio law that suggests common law claims of unjust enrichment are incompatible with trust case. And indeed, this court has applied those principles to this case in its recent Estate of Neal case. Finally, Your Honor, why is summary judgment warranted in the case? And as I said earlier, at its heart, this is a simple case. The plaintiffs have only a single remaining claim, and it's for common law unjust enrichment, which requires that they confer a benefit. And as this court explained in Deferent, a claim of unjust enrichment requires that the benefit must be conferred upon the defendant by the plaintiff, not by someone else. And this was the first element. And again, it is undisputed that every fee paid to Fifth Third prior to May 1st, 2015 was paid by the previous income beneficiary when it was taken from income that would have otherwise been given to that beneficiary. And that beneficiary was their mother. At no point prior to May 1st, 2015, did the 5 plaintiffs in this action confer a benefit by paying a fee. And finally, Your Honor, I would note he made an argument.
Before you move on, so
Yes,
just
ma'am.
so I understand, what is your argument about why that your current unjust enrichment argument was not available to be pursued previously?
Because your argument, or because Your Honor, that was not the complaint. It says that the basis of unjust enrichment was the failure of the duty to diversify. That is right there in the complaint. And it says the failure of the duty to diversify. Based on what they wrote, we believe we moved for summary judgment on the failure of the duty to diversify. And that was a breach of, and the court found those claims are barred by the statute of limitations. The first district found that it could be something other than the breach of the duty to diversify. And in that case, they said, well, it's based on excessive fees. I wanted to mention something. They talked about Rule 15B. 15B is inapplicable. 15B does not apply in cases that have not gone to trial. And this court's decision in Siegel v. Life Center Organ Donor Network says that. This case did not go to trial. And they also talk about amendment. I think the concept is amendment through an expert report. First of all, the civil rules don't allow someone to amend via an expert report. And all they did in an expert report is cite a revised code section, 5807.08A, which talks about the reasonableness of a fee. That does not put Fifth Third on notice that they've somehow changed their claim. Instead, reasonableness is inherently a part of unjust enrichment because if something's unreasonable, it can't be. And again, Judge Krause, I want to say, we had a different record before Judge Winkler the first time. That's why all those additional affidavits, depositions, and exhibits were submitted because we were litigating the issue of the elements of unjust enrichment. The first time we were litigating the failure of the duty to diversify as a basis of unjust enrichment. So the law of the case doesn't apply to what they're saying. And again, it's a rule of practice. It is not something that's mandatory. And we would submit that Fifth Third respectfully had litigated what it thought was the issue and what the parties had thought of the issue. I mean, we weren't going to spend our time litigating or filing a motion on something we didn't think was relevant at the time. No one would do that. And again, and I think it's important to note, it's based on the wording of count 4 of their complaint. We believed it was an unjust enrichment claim from the failure to diversify. They knew they were about to lose on statute of limitations. And so they said the unjust enrichment claim is based on excessive fees. And so now, because they can't prove unjust enrichment, they're saying, nope, we're bringing it on behalf of the trust. First of all, there is no claim for behalf of the trust. Second, nowhere in that complaint does it say that. They are individuals. They actually ask in their prayer for relief that the funds be returned to them, not to the trust. And finally, they're talking about, they don't want to talk about unjust enrichment. They talk about an excessive fee claim. There is no such thing under Ohio law as an excessive fee claim. It has been 7 years. And I just feel that at some point, Fifth Third should not have to play whack-a-mole with the plaintiff's complaint, guessing what are they bringing? What is their argument? Finally, I would say, Your Honor, it is time for this case to end. The plaintiffs have only their claim for unjust enrichment remaining. And as the trial court rightly found, they cannot prevail on that claim. And counsel admitted today that they cannot prevail on that claim because they never conferred a benefit on Fifth Third. And I'll note, the trust never conferred a benefit. Absent this most basic requirement, their claim fails as a matter of law, and Fifth Third would respectfully request this court affirm the judgment of the probate court. Thank you.
Thank you, Mr. Welton. Mr. Schlichter, you have 3 minutes remaining.
Thank you, Your Honor. Your Honors, no matter how hard Fifth Third strains to contort this case into something that it is not, this is a straightforward claim for unreasonable trustee fees.
Well, let me stop you there. Isn't it for unjust enrichment? Don't you have to meet the elements of unjust enrichment?
Your Honor, this is a quintessential breach of trust claim. And while the claim is labeled unjust enrichment, what it seeks is unreasonable trustee fees. And if you look at RC 580805.
Let me stop you there, though. We sent it back on only one ground, and that is because we said that the complaint did state a claim for common law unjust enrichment. I'm paraphrasing a little bit, but not a claim, a statutory claim. And in fact, aren't those the claims that we said were barred by the statute of limitations?
What the court did in its order was not say that there were no breach of trust claims that remain. It simply identified by the title of the claims, 1, 2, and 3, the claims that were being dismissed, unjust enrichment was remaining. But Fifth Third never made this argument before. So this court was never presented with the idea that this was solely an unjust enrichment or equitable claim. Ultimately, Your Honor, it's a distinction without a difference, because it is absolutely black letter law that a trustee can bring an unjust enrichment claim. I'm sorry, a beneficiary can bring an unjust enrichment claim against a trustee. That's in the restatement, that's in the Cigna case that we cite, and the other cases we cite. There is really no argument or case law that Fifth Third even purports to cite that says that a beneficiary cannot bring an unjust enrichment claim against a trustee, because that is done all the time. But addressing some of the other points that were raised, first of all, it is black letter law that a beneficiary may bring a lawsuit on behalf of the trust. RC 5810.02 says that, as does the Waltering case I mentioned earlier, as does the Bogert treaties, as does the other authorities in the restatement that we cite. Fifth Third's suggestion that that is not black letter law is not well taken. The idea that in this litigation, there was not a focus on Fifth Third's fees, there was only a focus on diversification, is directly contradicted by the evidence. And that was why this court overturned summary judgment on the excessive fee claim, because it wasn't related to the breach of duty to diversify claim. And if you look at our expert reports, TD 196 at 5253 and 761, you'll see that we very clearly segregated that claim and actually had different damages that we set forth in our expert reports related to Fifth Third's removal of excessive trustee fees that had nothing to do with breach of the duty to diversify. The idea that there is no new, that the record evidence is new here is simply a fiction. The record evidence that was put in connection with the first post-remand summary judgment motion led to the trial court denying summary judgment. Fifth Third subsequently moved again for summary judgment, but only on the one narrow issue that is now before this court. And that issue does not turn on any new evidence whatsoever. It only turns on the question that counsel has repeatedly come back to, which is the Clark siblings were not able, as remainder beneficiaries, to personally confer a benefit on Fifth Third. But that has been true throughout this litigation.
Mr. Schlichter, you are at your time.
Thank you very much, Your Honors.
All right, counsel, thank you both very much for your arguments this morning. We will take this case under submission and give you a timely written opinion. Thanks again. Ms. Hayden, if you will bring our next parties into the courtroom. Good morning, counsel. In our final case to be argued this morning, Miller versus Miller, we have Mr. Spaeth here on behalf of appellant, Ms. Stagnaro here on behalf of appellee. Mr. Spaeth, you will have 15 minutes to argue this morning. Would you like to reserve any time in rebuttal?
I would, Your Honor. I would like to reserve 2 minutes.
All right, and I will keep your time whenever you're ready.
Thank you, Your Honor. May it please the court, My name is Barry Spaeth. I represent the appellant, John Troy Miller, in this case. And we appealed the magistrate's decision because it does represent an abuse of discretion on the trial court's part, in that it was arbitrary, unreasonable, and even, we would argue, unconscionable in terms of the attitude displayed by the trial court in reaching that decision. Just by way of background, Mr. Miller had a business in the sports media or sports venue marketing field, in which he would run ads for clients on big screens that would be installed in the venues. In March 19, a year before COVID hit, the bottom fell out of that business. He lost his one big client, Geico, and then lost another client, substantially smaller than Geico, Kumho Tires. And as he testified, after those events occurred, he was left with about 20% of the revenue he had previously. So, and by the way, this was 2 years before the court's decision in May of 2021. This was pretty ancient in terms of history that would be relevant to what he was capable of making at the time of the court's decision. By early 2020, obviously, the bottom fell out of his business, or out of the economy, because of COVID. And as a result, his business went away. He did have some commissions in the first quarter, actually in January of 2020, that he had earned from Geico back when he had still been representing them a year earlier, back in, again, first quarter of 2019. He received those in January, $67,000. That was it. That was the last income he ever received from Geico. He got another job with ISM Connect in mid-May of 2020. That lasted till September 2020. And in that job, he was earning at an annual rate a salary of $96,000 a year. And he was supposed to be getting commissions too on any sales he generated. Unfortunately, he generated 0 sales. And as a result, not only did he not earn any commissions, he was terminated after 4 months. You know, it's interesting, the magistrate said in her decision, it was unclear why he was terminated from that position. Well, one of the higher ups at ISM Connect had actually testified in August, a month before he was terminated, that he could not guarantee that Mr. Miller's position was going to be secure because he hadn't had any sales. So it was very clear why he was terminated. And I think that comment in and of itself displays maybe a little bit of animus on the trial court's part towards Mr. Miller in trying to find a way to get to where he could impute some income to him. With respect to imputation of income, it's really a two-part test. One is the court needs to find that he was voluntarily underemployed or unemployed. And then if it does make that finding, it has to figure out what his potential earnings should be based on prevailing salary levels and job opportunities in the community and his recent work history. Well, his recent work history doesn't support a finding that he should be making $193,000 or any other amount. His recent work history showed that he shouldn't. It's more easily argued that it should be 0. He hadn't gotten commissions from Geico since since January 2020, and again, those were earned back in the first quarter of 2019. He didn't
how much income was actually imputed to him?
It was $193,891.
So
that was
the entire amount wasn't imputed, right?
Right, that's right. It was $96,000 in salary, which was his annualized salary at that job he had for 4 months.
So the judge imputed 96,000. That's
Yes.
what you're taking issue with.
No, well, we're taking issue with the entire 193,000 that she imputed.
Where you're saying he didn't have any income?
Yes, that's right. Well, the two parts that that comprise that total that the total comprised were gone by the time she imputed that income. He only had the job.
So how much income are you saying that he had at the time?
He had none at the time.
Well, either did his ex-wife.
That's correct. We're not arguing that she did have income.
Okay.
So
So that what the judge was supposed to just order no support at all, or?
well, there wasn't any basis for ordering support. I would argue that because there was no evidence of the type that's typically required, and certainly under the case law is required, to base the imputation of income on. Something like an expert witness report who would have done a vocational assessment, for example, or some other evidence of what the salaries and job opportunities were here in the Cincinnati area back in 2020 and early 2021.
But his major argument was that his salary was dramatically reduced, and what you're saying is to nothing, because of COVID. And I think the magistrate judge and the judge said they were taking that into account, but that they recognized that he got a pretty decent paying job during COVID. And so he was capable of doing that.
Well, I think it shows that he wasn't, because it only lasted 4 months and he made 0 sales during those 4 months. And the magistrate even said there, she talked about the fact that the job was eliminated after 4 short months. And it just sounds as though there was a little bit of animus on her part towards him.
What are you saying, that the magistrate thought that he did something to purposely get fired or let go?
No, I don't think that's it. But those months were no shorter than any other months. It was 4 months, and that's as long as he lasted. He made no sales, and it's not unreasonable it would not be unexpected that someone who makes no sales in 4 months would be terminated.
Wasn't something that was also kind of impactful to the judge and the magistrate was the fact that while he did try to reach out via email to find some other job opportunities, that there really wasn't that much work being done on his part to attempt to find other opportunities.
Well, he testified, she said he didn't really offer any evidence other than maybe a few emails. He testified about all the calls he made. He said he knew everybody in the industry, basically. It was a relatively small group of people who work in that field, and he knew them all, and he called them and found out there were no opportunities available. And in fact, as he testified multiple times over the couple of days of hearings, 65% of those of the people in that field had been laid off. But he did make the effort. He did make the phone calls and send the emails and do the work he could to find a job in his field. And it wasn't just COVID. Again, the GEICO commissions related back to the time they terminated their contract with him in first quarter of 2019. So that's when the train wreck really began, and COVID just basically finished them off.
Well, I mean, what we have to do is we have to determine whether the judge or the trial court abused its discretion, and certainly can't substitute anything that maybe we would have done differently.
No, and we're not.
Yeah.
Go ahead.
Well, I'm just asking you to kind of summarize the abuse of discretion here.
Well, the abuse of discretion was that the trial court took evidence that that Mr. Miller was no longer able, for whatever reason, not just COVID, to earn the kind of money he had made in the less recent past, up until 2018, say, from GEICO in particular, but in that field more generally. there was a commission from Geico from that he earned in 2019, received some of, but not all of, in January 2020, with no assurance that he would ever get the rest of it. So that we're already well over a year prior to the court's decision. And then he got another job that in which he only lasted 4 months, and in which he only actually earned $32,000. And somehow from those two components, the trial court came up with this imputed amount of $193,000 plus. And we're just saying the evidence actually shows the opposite, that he was absolutely no longer capable of earning that kind of money. It wasn't going to happen.
Ultimately, wasn't it the trial court's determination of the amount of the imputed income based on their determination of what they believe to be the experience and the abilities of your client?
Yes, I think to some extent there was an assumption. There were comments in there about how he had been historically successful, and there was no medical reason why he couldn't work. But that's not the test under 3113.
Well, that's among the factors to be considered, is it not?
Yes, but the statute requires more solid evidence than just a sense or just success in the past, finding that had occurred, and so there's the evidence shows that rather contrary to him being successful, he was anything but.
Okay, well,
And it wasn't his fault.
So there's two questions I have with regard to the imputed income. Okay, so one is, you've been talking about the different things that the court is to be considering in the determination of imputed income. That's statutory. Okay, so and early in your argument, you talked about how the court did not consider sort of like the industry information. Whose burden was it to have that as part of the record?
Wife's, Mrs. Miller's. She needed to come in and present evidence that there were jobs available that he's just not availing himself of. And there was none of that kind of evidence presented.
And can you point to authority to support that it was the wife's burden?
Yes, English v. Rubino. That was a case in which an attorney who had worked in the banking industry looked for jobs as an attorney in banking, and testified about the fact that he had looked and hadn't been able to find any. And the court said, essentially, that the opposing party, the spouse, needed to present evidence that there were jobs out there that he did not avail himself of.
Mr. Spaeth, you are at your time unless the panel has any other questions.
I do have another question. So going to the imputed income, the other thing that I noticed is that the wife had testified that your client had skills and had experience beyond the in-venue signage experience. She talked about promotions and parties and gave an example of a particular client that your client had represented in that arena. Was there anything improper with the court considering that as part of your client's experience and abilities?
Well, that doesn't go very far in establishing what jobs were available and what the salaries for those jobs would have been. But he did testify about looking at jobs in other industries, jobs that were more or less at the same level at which he had been working in the sports venue marketing industry. VP of sales jobs in different industries. I think there was one job that he looked at in the CBD distribution industry, and he couldn't find any of those jobs either. So it's not as though he didn't look, but it wasn't necessary that he come in and present expert testimony or other evidence of all the jobs that weren't there. The burden was on her. There's no presumption that there are jobs out there that he's just not going after. The burden's on her to show that there were jobs there, and he just didn't bother to try to get any of them.
Thank you.
Mr. Spaeth, you are at your time if you'd like to reserve two.
I still would like to, Your Honor. Thank you.
All right, Ms. Stagnaro, you've got 15 minutes.
Thank you, Your Honor. This matter actually started back in May of 2020 when Mr. Miller filed a motion to modify his support obligation because he was no longer running his business. And he instead had gotten this position at ISM Connect, making $96,000 a year plus commission. He then filed, once he lost that position, he filed another motion, I believe in October of 2020, saying he was no longer capable of earning any money and there should be a zero support order because he had lost that position. So I know that Mr. Spaeth would talk a little bit about how it's been 2 years, but he filed the motion pretty quickly after he got the job with ISM Connect. And then when he lost that position as well, it just took some time for it to work through the judicial system. But as has been pointed out, what we're looking at today and what this court's standard of review is whether the trial court abused its discretion in making the support order that it did. And basically, the court is required to accept the court's findings of fact as part of the record. And if there was not competent or credible evidence to rely on in the court making its decision, that's something the court can consider, or whether the court was unreasonable, arbitrary, unconscionable, or the order was contrary to the law. We believe that there was plenty of competent, credible evidence for the court to rely on in making the decision that it did. So starting with kind of the first assignment of error is whether Mr. Miller was voluntarily underemployed. Our argument is, and the trial court found that he was. And as a result, the court had the ability to impute potential income to him under the terms of 3-11901. So, and part of those factors, as been pointed out by Justice Zayas, is that we look at prior experience, education. These are important tools for the court to consider when looking at imputing income. But getting first back to the voluntarily underemployed, I know that
voluntarily underemployed, it comes down to what was the evidence that he had made continuous and diligent efforts without success to find and accept employment.
Correct. So
one
it
of the
started
arguments this morning is that there's emails of, and I forget how many it is, if it was 20 or so folks that Mr. Miller had reached out to within the in-venue signage industry. But I also heard the other part today was that that he had testified that pretty much is the list of contacts within that industry. Is that accurate?
I don't know. I mean, I know that's what Mr. Miller testified to, but when the court is looking at whether someone is voluntarily under or unemployed, I mean, certainly the first step is to go through contacts or in the actual field that you're in, but that's not where it stops. I mean, he has over 20 years of experience in sales. He has education in marketing and sales. My client testified that even before he started in this more niche area of sports signage, he was doing all sorts of different sales, and he was doing things other than necessarily sales, more in the marketing realm. He had his own business that was extremely successful for 17 years. At the time of the divorce, he was making well over $300,000, and that continued in basically 4 years after the divorce. This is not a gentleman who didn't know what he was doing or that didn't have the ability to generate income in sales.
I understand that argument. Part of that argument, isn't it sort of premised on also industry information? What's out there in different industries, what's available. Whose burden was it to bring that evidence into the record, if anybody's?
So the case law states that it's basically my client's obligation to bring this to the court's attention. However, that doesn't mean that Mr. Miller doesn't have the burden also to say what he actually did in order to try to live up to his potential earning abilities. I mean, for him to be able to say, I sent a few emails and I made a couple of calls, I asked him questions like, is there anything that is preventing you from going out and getting a job, health-wise, physical, mental, whatever? He said no. He didn't do any postings on any online services such as Indeed or ZipRecruiter. All he did was reach out to the people he knew in quick email saying, hey, do you have something for me? And then just accepted that they said, well, right now we don't, we'll put you on the top of the list. And that's all he did, even if he made some few phone calls. You know, for him to be able to say, I made every effort to find employment, we know that's not true. He was able to, in the midst of the pandemic in April, May of 2020, to go out and find a position that had salary of $96,000. I mean, and that was within a couple months of him saying that he wasn't operating his business any longer, which we know is also not true.
I believe the testimony was that the job came to him, not that he came to the job.
Well, right. His company had done work with this company. And that's why they brought him on, knowing his sales experience and his success in this field, that he was going to generate income for them. In addition, took over his contracts, such as Geico, hoping that they were going to earn some income as a result of that as well. And that was another question I think the magistrate raised, is there's these contracts that ISM acquired from Mr. Miller's companies that are due to pay out. And we don't know what actually happened with them. But regardless, he was able to get this position. And it's hard for anyone, and I think the court made this comment too, to believe that in 4 months, he was not able to generate any sales whatsoever. Mr. Naoti testified that there were other salespeople that were working. He testified this in August, that were generating sales. So it's really hard to believe that, given his breadth of experience, that he wasn't able to make any sales. And then within basically 30 days of child support coming out of his paychecks, now he no longer has this position based upon a phone call from this company he supposedly had a working relationship with. But I digress. What I'm getting at is that the case law is very clear that you can't just sit back and say, well, something's not landing in my lap, so therefore you can't impute income to me. He had the obligation to go out and find a position commensurate with his experience, which he did in the middle of the pandemic, and then chose not to after that, or to run his business, even though his website's still up and running, even though he was still renting space for his business. And he was operating.
Just sorry to interrupt, but he didn't, I mean, the evidence wasn't that he chose not to try to find something. I mean, he did, as you said, try to contact the people within his industry that he knew, and that was evidence. I feel like what you're saying and what the trial court said is that he didn't try hard enough.
And I would agree with that, because even if he couldn't find something in his specific niche, although that's questionable too, I mean, he, with his experience in sales, could have gotten a position. You know, I went on Indeed and found 50 positions he could have applied for, making over $100,000 a year.
That's not part of our record, so
I
let's
understand.
stick to the record.
Thank you, Your Honor. But what I'm saying is that was his obligation to do. He chose not to do that because he wanted to stay in this particular field. And
so if he would have presented some sort of evidence that he got onto Indeed and these various other websites and put his resume up and was trying to find a job that way, would that have been enough? And nothing came?
I think it would depend on what he shared, but I think that would go a further step than what he actually did.
And
So the issue really is that he just didn't try hard enough to find a position.
So turning to the issue of the imputing of income. So we get, we only get to there if there's a determination of voluntary underemployed or unemployed. So going to the imputing of income, the argument is that there was no income. And the trial court did accept that the magistrate had taken note that we were in the middle of the pandemic. So what is your position? I mean, obviously your position is that the amount was correct. How would you support that?
Well, as I said, I mean, he was able to go out in the middle of this pandemic at its height and obtain a job making $96,000 a year, plus commission at 10%. And so obviously the jobs were there, his experience was there. He had the ability to at least make that at a bare minimum.
But there were two things that were taken into account. One was the base salary for ISM, which at the time the ISM employment was no longer there. And the other was under the sort of the residuals that were agreed upon from the termination of his Geico account, was what was expected to be paid out in Geico on that year, which obviously was only for that year, was not going to carry over into another year. So why is that total amount accurate and correct for imputing income?
But I think when the court is looking at the income, they're going to be looking at not only past income history, especially if you have a variable position, but also what they're likely to make into the future. And so what the court did, I believe, is that they used that money that was supposed to be in Mr. Miller's hands in that year by contract from Geico to impute. And if you look at the whole is 193,000 that was imputed. Again, Mr. Miller's income historically, or at least since the divorce, was well over 300,000. In October of 2019, so just months prior to him obtaining this position and saying he can't run his business, he agreed that his income was $393,000. So, and that's after he lost both of those huge contracts. So if the court is looking at the totality of the circumstances, his past income history, his potential income, I think what they imputed was a lot less than they should have. And that is, they should have gone with what he historically had made. Instead, the magistrate basically cut that in half and said, we know this is what we think is a guarantee that he should receive. But he also testified he still had things in the pipeline, including some sort of contract with the Bengals that was supposed to pay out in 2021. He wasn't specific with that amount, but obviously he still had irons in the fire that would generate income for him. And I think that all that was considered by the magistrate.
One of the issues raised is with regard to the deviation of the child support worksheet. And I noticed that with regard to the son, that there was, and I forget how many days, it was like 100, it wound up being like 170 something days that the son would be with dad based on the worksheet that was worked up, right? So why shouldn't there be more than the 10% deviation, since there's more than 90 days that son is with dad?
So I will go through the factors in just a second, but what I want to point out is my client, first of all, testified that under the terms of their agreed entry in October of 19, they had equal time with their son. I know Mr. Miller has said repeatedly he had Austin 100% of the time or most of the time. That's not true.
That's why I'm just going to the worksheet.
Right.
Okay?
So
because then we're not even to abuse of discretion if we're looking at the worksheet, right? So the worksheet says what it said, right? Was determined what it was determined based on the testimony, the conflicting testimony.
Right. So currently under our law, our child support law under 3119-051, if a parent has at least 90 overnights per year per child, it's a statutory automatic, you get a 10% deviation. So that's what the court awarded, because there's no question that Mr. Miller had more than 90 overnights with both children, despite what the agreed entry said. So that was an automatic. The question, and what Mr. Spaeth is arguing, is that Mr. Miller should be given an additional deviation because allegedly Austin lived with him primarily, even though Bella primarily resided with my client, and that wasn't disputed. So then we go to the factors in 3119.24 as to whether there were extraordinary circumstances that would warrant the court to deviate more than that 10%.
But isn't there also a provision when it's when it exceeds 147 overnights a year?
So it's not actually in the statute. I know that was something that was being thrown around in the legislature to give an upwards of 40% deviation if there's more than that, but that wasn't actually codified. So it's more of, you get the 10% at 90 or more overnights, but then it's the trial court's discretion whether to deviate more than that when you have additional time and you have to look at the other factors. And because it's shared parenting, we not only look at the deviation factors in 0.23, but we have to look at the deviation factors in 0.24, which require the extraordinary circumstances. So in looking at, again, it's discretionary and based upon factors. What we have here, we have a father capable of earning a significant amount of wage. We have a father that is still paying $1,200 a month for his car, over $2,000 a month for his house, his cleaning lady, $10,000 to $13,000 a month on credit card debt, where my client had absolutely zero income, was living with her boyfriend. If it weren't for that fact, she would have been homeless. So to further deviate, given the circumstances, after income was already cut in half from what he had previously made, I think the court was absolutely correct in not giving any additional deviation and looking at factors.
Ms. Dagnaro, you are at your time, unless there are other questions from the panel. Any other questions? Mr. Spaeth, you have 2 minutes remaining.
Thank you, Your Honor. Yeah, again, it has been discussed. Mr. Miller did find a job. It's not as though he wasn't looking. If he hadn't been looking, he wouldn't have found one, or he wouldn't have accepted the one that was offered to him. However, it came to him. So the job at ISM Connect is one he found after his business had been decimated, first by COVID, or by Geico taking away its business, and then by COVID. And the fact that the ISM Connect job only lasted 4 months is indication that for whatever reason, it's not very easy for him to come up with a long-lasting source of income at the level at which he was earning during the marriage and for the first few years after the marriage.
Mr. Spaeth, was Ms. Dagnaro accurate that the evidence is that he did not post his resume to any of the online services, nor did he hire anybody to help him find something?
Your Honor, I don't know that I can completely answer that, but my recollection is he did talk to some people who were involved in, or at least one person involved in some sort of online job search function. But as he testified, the jobs that he was looking for in the industry that he was in, you don't find on LinkedIn or monster.com and sources like that.
But he didn't, the law isn't that he gets to stay in the exact industry he was in, is it, before he considered underemployed?
No, although I think it's the Rubino case in which the court said, look, if you're going to impute income based on what he was earning in that industry, then don't look outside the industry for other sources of employment. So, we have two inappropriate sources on which imputation was based. One going back to the first quarter of 2019, and one a job that lasted 4 months in the middle of 2020. And when was he supposed to be looking for another job, by the way? He went out and got that job and still had it at the time of the August installment of the hearing, and then had just lost it the month before the October installment. So it's not as though he wasn't doing things.
And
There was a lot of time in which to do them.
You are at your time, unless the panel has any additional questions for you this morning. Any questions? All right. Thank you both very much for your arguments this morning. We will take this case under submission and give you a timely written opinion. That will conclude the arguments this morning for the First District Court of Appeals. Thank you very much.
Thank you, Your Honors.